Good afternoon and welcome to another edition of the Waterstone Weekly Updates. My name's William van Roosmalen. I'm one of the lawyers here, and joining me is Damien Grant, liquidator. Damien, how are you this afternoon?
Am I really a liquidator?
Former liquidator.
Former liquidator. Past and maybe future liquidator.
Yes.
We'll see how things go.
Yes.
All right, we're talking about
Fatupaito and Bates.
rather a famous case.
Quite well cited. I remember it from law school.
And when at law school, what aspects of the case did they refer to?
I can't remember much
So it's
of
not
law
very
school.
helpful at all.
So
You can't remember much of law school. This is the
No.
calibre of lawyers that we have at Waterstone, yes. Bit of a
it kinda-
drunken haze, was it, law
Well,
school?
it goes in one ear and then you cram it in, chuck it on the paper, and then it goes out the other ear.
From my understanding of the case, the thing that gets most of the traction is this was the first case where the issue of a deemed director was
Right.
kicked around. And I'm a little bit surprised that the case has actually got so much traction, because if you think about what is a deemed director, this case wasn't really on the margins. So the company called Metalsmiths, and in the business of doing metals. And the company was in some trouble, and a gentleman by the name of William Bates cropped up and said, "Hey, I'm a business advisor, I'm going to give you some help." And the director, Mr. Moon, said, "Great, I'd love to get your help." Mr. Bates provided help, but it didn't solve the company's problem. They were still in trouble. And then Bates did something a little bit weird. He looked at the Companies Act, and he read the receivership section, and he says, "Oh, we can put the company into receivership." And
Read the Receiverships Act.
yeah,
As well.
he flicked through it and says, "Oh, we can do this." They then went onto the company's office and just put the company into receivership, making Mr. Bates the receiver. Now the problem was,
As you can do.
you can do, because back then, of course, it was an unregulated industry, and any idiot could be a liquidator, as opposed to now, which only people of good character can be liquidators. Mr. Bates then assumed office as a receiver, but there was no underlying debenture or general security agreement underpinning that.
Well, he had no appointer. He had no one trying to secure their interest.
And it doesn't look like Mr. Bates was doing anything dishonest. He just didn't understand the Act.
Which is odd for, he was
An accountant and business advisor.
Yes.
Yeah. And if you look through the Act, it even looks like he considered putting the company into liquidation. So he obviously must have understood the difference to some extent between receivership and liquidation, but maybe he thought receivership was a bit like voluntary administration. Who knows? Doesn't really matter. Point was that the company was not actually in receivership, despite the fact that Mr. Bates was holding himself out to the world as a receiver. That's important in a sense, because if Mr. Bates had been a receiver, he would have been personally liable for all of the debts of the company anyway under the Receivership Act. But he wasn't the receiver. He was just holding himself out as the receiver. The Inland Revenue Department ultimately put the company into liquidation. And the issue became, at the time Mr. Bates took over, the company was in the hole for about $15,000.
not a huge amount.
Not a
well,
huge
maybe
amount.
in the day.
But between the time that he took over and the time that the liquidators arrived, the deterioration in the financial affairs of the company, according to the liquidator, was $59,000. So the financial position of the company deteriorated by $59,000 under the administration of Mr. Bates. The liquidators then went to court and says, "Hey, under Section 126 of the Companies Act, you, Mr. Bates, are a director, because a director is not merely somebody who signs a paperwork to become a director and is registered on the company's office website."
Now, this I do remember from law school. You can
Right.
be deemed a director if certain things happen, like you have effective control over the company
Yeah.
and its day-to-day operations,
Yep.
which is a factual analysis, right? It
Yep.
depends on the facts. Was he a deemed director?
Or was he, under the Act, it says, "In this Act, director in relation to a company includes a person occupying the position of a director of the company by whatever name called." So it doesn't matter whether he was a director under the Companies Act, whether he signed the paperwork or not. The question was he acting as a director?
Or holding himself out as a receiver, which he clearly was not.
Yep. And then the Act also says, a person whom a power of duty of the board has been directly delegated by the board with that person's consent or acquiescence. So what the liquidator said is, well, the board, who was Mr. Moon at that stage, had delegated powers to Mr. Bates, and Mr. Bates was acting as if he was a director and was making decisions as if he was a director. And so it wasn't a stretch for the court to turn around and says, well, actually, Mr. Bates, you are a director. Bang. And once he became a director, then that opened the door for the liquidators to say, hey, as a director, you have director's duties, Section 135 and Section 136 in particular. So they pursued him on that. Now, for Mr. Bates, it was kind of a win in a sense, because the fact that the company wasn't in receivership meant that he wasn't automatically liable for the debts of the company. So in a sense, his incompetence in that perspective, was potentially a saving grace for him, other than the fact that the court says, well, actually, if you're running around pretending to be a receiver and you're not, you have effective control of the company. You've got delegated powers from the board as a director. You're a director. And then the courts then went on and had a look at the Section 135 and 136. And so going back to law school, was that the thing that the law school...
I think it was, in terms of the fact that this is a pretty rare scenario, and it's a very unique situation. He was educated and he was making decisions that materially affected the company, ultimately for the worse. So it's a pretty clear scenario, I think, where the court was able to deem him.
It's a pretty extreme case. Most of the subsequent cases on this issue, it's been much more of a line ball decision. And I think why this particular case has got so much traction, it was simply the first time that this issue had been brought to the court's attention. And the judgment make reference to that. So they rely on some overseas authorities. But this is such an extreme case, such an obvious and blatant case, that I don't think the court had anywhere else to go. And so it's been cited and referenced, although I think the case still has probably moved on a little bit since then. But then the other issue is, well, okay, Mr. Bates was a director. Did he breach his duties as a director? And here, we come back to some fairly more standard issues. So, Section 135, did he trade recklessly? And we actually see, I think, because Debut Homes is a case we've talked about it previously, and it was in our last Waterline newsletter. And there's kind of a bit shades of the Debut Homes case in this case. So there was a debate going on in front of the court in this particular High Court case, where the director was claiming, hey, so why did Mr. Bates get into trouble? So when the company went into receivership, there was a whole pile of jobs still to be completed. It's not clear what those jobs were, but some sort of metal craft.
Yes, construction.
Probably creating some form of metal design, artwork, something, who knows.
But the judgment said that those accounts receivable, let's call them, they paid some
deposits,
30-odd% deposit, and so the back end of those payments were the more substantial part of it. So Bates was arguing that majority of the money would be coming in at the back end, and so it was that reason why he decided to trade on as opposed to placing the company into liquidation straight away.
Well, let's just back up a point. So, because one of the things the judgment said is that if you're a company director and you find your company in trouble, you don't have to end the business straight away.
No.
You can make a reasoned decision. And it's interesting because I think there's a difference between this and the Debut Homes case, because here in this judgment, the court saying that you should look at the total body of creditors, whereas in Debut Homes takes a slightly different tack. But nonetheless, Bates had a quick assessment and decided to trade on. The liquidators argued, and the judge agreed, that Bates did not do a proper analysis. And if he had done a proper analysis of the jobs, he would have realised that he just didn't have the ability to complete the job. He had other problems as well. So the company itself had never really performed on its obligations. There was always issues of workmanship and timeliness. They had other problems, and they've been losing staff.
They also had a bit of a discussion, this might be the point that you're coming to now, about whether or not there is any reasonableness element to the breach claim and whether or not the director can take reasonable risks that might have some risk to loss for the creditors, but also some potential benefit in the overall scheme of things.
Yeah, so in section 1 through 5, they're talking about a substantial risk. So, it's okay to take a risk. Everything in business is a risk. But in this situation, it was a substantial risk. And the court also made the point in this case, and it's been repeated in subsequent judgments, when the company's insolvent, you're not gambling with your money, you're gambling with the creditor's money.
Sure.
And so the court was, in terms of section 1 through 5, reckless trading, the court said, well, Mr. Bates, you did not do a proper analysis of the existing jobs. You didn't do a proper analysis on the likelihood of the debtors being paid. So the decision to trade on, once he assumed office as a receiver or a purported receiver, that was reckless. Then they jumped into section 136, and section 136, different conceptually, although not always practically, from 1 through 5. So section 136 is in terms of a specific obligation. So if you as a director, you incur an obligation, do you have reasons to believe that the company will meet its obligations? And here you get all of this subjective, objective tests. Do you remember the difference in subjective and objective?
Well, it's the court has to make a decision in his shoes, effectively.
That's a subjective test.
Yes, so the subjective element is that the analysis has to be done as he would have seen it, and then was that a reasonable decision?
And it's the reasonableness that is the objective part.
Yes.
So the question is, when Mr. Bates made the decision to incur additional liabilities, did he honestly himself believe that the company could meet the obligations? So that's a subjective thing. What did he actually think? Doesn't matter whether he was right or wrong. What did he think? But then he needs to think that on reasonable grounds, and that's where the objective part comes in. So if you believe that you can meet your obligations, and you genuinely believe you can meet your obligations, and you genuinely believe that because you're going to win lotto, then it's the winning of the lotto part that is objectively not correct, unreasonable. So objective means what would a rational person think in that situation. And so the court says, well, okay, even if Mr. Bates subjectively believed that the company could do it, he had no...
That's not enough.
He had no objective basis to do that. And in this situation, the liquidators turned around and says, well, the debts at the start of the receivership, the company was in the hole for about 15 grand. There was a deterioration in the net balance sheet of the position of the company by $59,000 over the period of his administration up until the time of liquidation. The liquidators wanted the full 59 grand. The court said no, gave him some discount because there were some issues, stuff relating to a car and debtors or whatever, that the court said that was realistically outside of Mr. Bates' control. And so they gave him a discount, and so he was paying for $30,000.
And it's just reflective of the very odd circumstances in which this happened, because you would assume that an educated accountant would know that there was no entitlement to appoint himself as a receiver. And so he opened himself up to all kinds of exposure, basically, because he was acting in a way that was inconsistent with industry practice.
But now we live in a regulated environment. Well, we won't have these sorts of problems. Only upstanding people of good character. Although there's no evidence that Mr. Bates was not a good character. In fact, there's a couple of comments here that indicate that he was a good character. So he clearly didn't understand the Receiverships Act, but he didn't charge the company particularly much. The liquidators
modest
conceded,
fees,
that his fees were modest. It does appear that he was attempting to do the right thing. So he does appear that he was a good person.
I don't think he's personally criticised in that way.
No, he's not, and the court seemed to have some sympathy for him. And looking at the liquidators report, it looks like he paid the $30,000 to the liquidators. But this case really has taken a legacy all of its own, and it's a little bit surprising when you go back and you have a look. The very extreme specifics of this case. It's surprising that this case has loomed so large in our imagination, but I think simply because these liquidators had the foresight to actually look at the Section 126 and apply it, and it looks like no other liquidators up until that point had done so. So congratulations for them for that. At least one of the liquidators became a life member of returns, I understand, so that's nice. And I think that's us. Any other comments?
Yeah, I mean, from me, I just think that it's not usual that you would take such a long-standing principle out of what is such a fact-specific case, but it's interesting nonetheless, and
it's a really interesting
the fact that
case.
we're still talking about it to this day, obviously
20 years later,
shows that it's got some relevance still. So thank you very much for joining us. Thank you, Damien, for your comments, and
thanks, Will.
we'll see you guys next time.
Thank
Cheers.
you. Bye.
Thanks.